Security Guard Training Course, Section 7, Canadian Legal Systems. Security guards work within the Canadian legal system. They need to be familiar with the Criminal Court System, the Ontario Evidence Act, and the Canadian Evidence Act, and how these apply to their positions to ensure the information they obtain is admissible in court. As a security guard, your primary function is protection. You will ensure the safety of people, property, and information. The Private Investigator and Security Act sets out guidelines in addition to the regulations set forth by the standing orders and post orders. Every security guard shall wear a uniform while acting as a security guard. Every security guard, while on duty, shall carry the prescribed identification card issued to him or her under this Act, and shall produce it for inspection at the request of any person. Failure to comply with these regulations may result in a maximum $2,000 fine and cancellation of your license. Canadian Criminal Court System. Provincial courts try most criminal offenses and, in some provinces, civil cases involving small amounts of money. Provincial courts may also include specialized courts, such as youth courts, family courts, and small claims courts. The provincial governments appoint the judges for provincial courts. Superior courts, the highest level in a province, have power to review the decisions of the provincial or lower courts. The federal government appoints the judges to these courts, and their salaries are set by Parliament. Superior courts are divided into trial level and appeal level. The trial level hears civil and criminal cases and has authority to grant divorces. The appeal level hears civil and criminal appeals from the Superior Trial Court. These levels may be arranged as two separate courts. The trial court, named the Supreme Court or the Court of Queen's Bench, and the appeal court, called the Court of Appeal. In some provinces, there is a single court, generally called a Supreme Court, with a trial division and an appeal division. Canadian Court System. The Supreme Court of Canada. The Supreme Court of Canada is the final court of appeal from all other Canadian courts. The Supreme Court has jurisdiction over disputes in all areas of the law, including constitutional law, administrative law, criminal law, and civil law. Federal Court. The Federal Court and Federal Court of Appeal are essentially superior courts with civil jurisdiction. However, since the courts were created by an Act of Parliament, they can only deal with matters specified in federal statutes or laws. Provincial Territorial Courts. Each province and territory, with the exception of Nunavut, has a provincial or territorial court, and these courts hear cases involving either federal or provincial and territorial laws. Provincial and territorial courts deal with the most criminal offenses, family law matters, except divorce, young persons in conflict with the law from 12 to 17 years old, traffic violations, provincial and territorial regulatory offenses, and claims involving money up to a certain amount, set by the jurisdiction in question. Private disputes involving limited sums of money may also be dealt with at this level in small claims court. In addition, all preliminary inquiries, hearings to determine whether there is enough evidence to justify a full trial in serious criminal cases, take place before the provincial and territorial courts. Preparing for a court appearance. All security guards who are requested to attend court to testify and give evidence must ensure they are prepared with all the relevant materials pertaining to the case at hand. Some of the common materials required are memo book, notes taken at the time of the incident in question, report, the subsequent compiled information after the investigation has been completed, and bar notices. This is any documentation to support the case, any other relevant materials such as videos, digital recordings, photographs, etc. Once you are aware that your attendance is requested, you are to initiate the collection process of all documents used relating to the case. Check with your company and the site location where the incident occurred. Tell them you request the material for court and arrange a time to retrieve the material. This should be done well in advance of the court date, in case any material is missing. Evidence Acts. There are two Evidence Acts, the Canadian Evidence Act and the Ontario Evidence Act. Personal Information Protection and Electronic Documents Act. As a security guard in Ontario, you will be governed under the Provincial Evidence Act for most of the offenses that you will deal with that are of a serious nature. The collection of and presentation of video evidence is regulated by both the Ontario Evidence Act and ppt7. More than likely, the only evidence you will have to give will be from the issuance of parking enforcement activities in traffic court. Evidence preparation and collection. Evidence preparation is very important. Do not touch anything. Secure the area and call the police. Do not let anyone in until the police arrive and then they are in charge. Record everything you have seen and/or touched. Do not leave the crime scene until the police advise you to do so. Do not disclose information to the media or others not directly involved with the crime scene. Principles of evidence collection. Collecting evidence is a very difficult task for most contract security, as there is no way to properly secure, preserve, and maintain continuity of evidence. The following 6 steps should be followed when you encounter material you think might be evidence. Collect the evidence. Secure the material. Preserve the evidence. Identify the items. Maintain continuity of evidence. Log what you collect. Being able to identify evidence, document, collect, and package evidence correctly from a crime scene is a difficult task. The following steps cover the basics. Remember, it is always best to leave the collection of evidence to the professionals if possible. Collecting evidence. Identify what evidence is relevant to your investigation. Once it has been identified, then record all the details before actually collecting. Location, temperature, preliminary identification, colors, etc., must be recorded in your memo book. Photograph the evidence and use a scale, a small ruler to assist with dimensions. Secure the evidence in a plastic bag and seal the bag with evidence tape and fill out an evidence tag. To be admissible in a court of law, physical evidence must be properly documented and be identified by every person that has handled it. This chain of custody begins with the person who first collected the physical evidence.